Very nice.
According to paragraph 11 below, if
उसको
it is
कोट करके
proposed
डिस्पोजल कर देते हैं.
lordship, no problem below. Because regulation KGB they have lost another court members.
नहीं फाइल. परेशान मत करिएगा बिना काम के.
हुजूर चल रहा था, हम दौड़ते दौड़ते हुजूर.
नहीं, हम ये नहीं बोल रहे हैं. जो टीचर्स लोग पढ़ाई कर रहे हैं, पढ़ा रहे हैं, उन लोग को अननेसेसरी नहीं परेशान. को टर्मिनस का क्या मतलब होता है? को टर्मिनस मतलब टिल द एज ऑफ सुपर एनिमेशन.
हाँ, वो तो है जो है. इसकी स्कीम गोज और सब पॉलिसी डिसीजन चेंज
नहीं, ऐसा तो नहीं. टिल द स्कीम एग्जिस्ट यानी कि टिल एक केस आया हुआ था यहाँ पर ऐसे ही.
जब 100 साल चलेगा तो 100 साल
एक केस था यहाँ पर.
सब्जेक्ट टू पॉलिसी डिसीजन में लो ऑलवेज
सब्जेक्ट टू पॉलिसी.
सब्जेक्ट टू पॉलिसी.
यस
यस. कोई सुपर एनिमेशन के एज भी है क्या?
60 years.
60 years.
हुजूर एक वाकया याद है, कोऑपरेटिव में 3 साल से 5 साल हो गए टेन्योर, और 3 ही साल में इलेक्शन का नोटिस आ गया तो हमने स्टे करा लिए. तो 5 साल हो गया, क्लाइंट को बोले भाई 5 साल हो गया, बोला सर स्टे है. हमने क्या 7 साल रहिएगा, थोड़ी रिजाइन कीजिए.
beyond age of superannuation.
I remember that person. I got him resign कि 5 साल हो गया भाई, टेन्योर ओवर हो गया, अब नहीं बढ़ सकता है स्टे पर उसका.
WPS number 157 of 2023. Appearance memo दे दीजिए. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that so far as prayer number Roman 1 and Roman 3 are concerned, the petitioner is not the petitioners are not pressing the same in view of the fact that there are and a judgment has been passed by this court in WPS number 7439 of 2019, wherein the claim of regularization of teachers working in Kasturba Gandhi School has been denied.
ये बीआरपी सीआरपी था हुजूर, ये बीआरपी सीआरपी का था. इसी स्कीम में सब शिक्षा अभियान में ये है कस्तूरबा गांधी का जो रिजेक्ट हुआ, इंक्लूडिंग टीचर्स ऑल कस्तूरबा गांधी पर्सन्स. ये है इसमें बीआरपी सीआरपी का.
Claim for regularization of Kasturba Gandhi regularization of teachers working in Kasturba Gandhi residential girls schools has been denied in WPS number 602 of 2019. By judgment dated 19/2/2024. The learned counsel submits that the petitioners would be satisfied if the writ petition is disposed of by recording the statements made in para 9 to 12.
11.
9 to 12.
9 to 11.
9 to 11.
Yes, please.
9 to 11 of the counter affidavit filed by respondent JEPC. Respondent number 4 to 20 JEPC. The learned counsel appearing on behalf of respondent number 4 to 20 within the JEPC has no objection to the aforesaid submission. He has submitted that the continuation of the petitioners would certainly be subject to policy decision of the respondents, and they would be entitled to continue at best till they attain the age of superannuation as per the norms governing the petitioners. Okay? After hearing the learned counsel for the parties, this court finds that the claim of regularization has been rejected by a coordinate bench of this court in WPS number 602 of 2019, and consequently the petitioners have not pressed the prayer number 1 and 3 of the writ petition.
They have filed IE also for that words.
Okay, that should be sufficient. However, a specific stand has been taken by respondent JEPC that the service of the petitioners are on short-term contractual basis, and further a reference has been made and further their engagement can at best continue till the scheme continues. A submission has also been made that their continuation would be subject to policy decision, and at best they can continue till the age of superannuation. Paragraph number 9 to 11. Nine to 11, 9 to 12, 9 to 12 of the counter affidavit is quoted as under. In view of the stand taken by the respondents in the counter affidavit, this court is of the considered view that no further order need be passed in this case. Accordingly, this writ petition is disposed of as such.
Deep learning.
Yes, one apology minutes. I filed one severe plus in a very exceptional situation. Morning I could not plus one case was called out. If Lordship permits, I can.
No, once the order is reserved, we are not going to entertain any idea.
Yes, very incriminating facts transpired thereafter.
We do not know.
I mean,
If
bearing
if
upon the
anything which transpires after the pronouncement of judgment and anything which comes, you have a liberty to file review petition or whatever. Once the order is reserved, you can't go on filing like this. It is not something which you have come across for the first time after the order is reserved.
One judgment in a similar situation
No,
was it was
please.
entertained.
You can just, we will not entertain like this. It is as good as a CAB order. Actually, I do not intend to have a CAB order. When a date is fixed, it's a pressure on me also that I have to pronounce a judgment.
I thought 100 times.
Therefore, I fix a date
Because
myself for judgment.
Before filing this,
And at times it is not finalized, I give a fresh date also. There is no problem.
I thought 100 times before I could file notice. It was two way.
You should have thought 101 times.
I thought I will file a review, I will file a LPA, but I thought if this incriminating facts is coming,
No.
better to brought on
It is
record
not.
before it is pronounced.
It is.
So it is all bona fide notice
No,
petition.
that's right, whatever it is.
Fairness.
We will,
As your
it can't
lordship
be like
believes.
this. We have given
Subject
you
to minutes.
sufficient time, sufficient
Grateful
opportunity, sufficient hearing.
2-3 paragraphs in counter affidavit was found to be very
We will
bona
not
fide
entertain.
and suppressive.
We will not
As your lordship
entertain.
believes.
Also, case from supplementary list item 4, WPS 6091 of 2023.
You have seen the judgment?
Yes.
So, nothing remains,
No, Your Lordship.
right?
Direction can be given to that compassionate appointment committee.
Yes, to consider that judgment,
Yes.
right?
With respect to that point only, Your Lordship.
Only with respect, because that is the only reason.
Yeah, that is the main.
That is the only reason I think. WPS number 6091 of 2023. The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the husband of the petitioner was working as chowkidar, who died in harness on 25/12/2016, and the petitioner applied for compassionate appointment, which was duly allowed, and she joined on 27/10/2021, and since then she has been discharging her duties continuously. He further submits that the petitioner has done her matriculation from Prayag Mahila Vidyapith, Allahabad, which was permanently recognized by central government as well as Jharkhand Academic Council Ranchi, and the certificate was sent for verification, which was found to be genuine and correct. But a memo number 465 dated 26/6/2022 was issued cancelling the appointment of the petitioner on the ground that the persons who had obtained 10th pass educational certificate from outside the state of Jharkhand are not entitled for appointment. The Learned Counsel submits that thereafter the matter was taken up and 2 years' time was granted to obtain a fresh certificate wide meeting held on 11/8/2023. And thereafter, the Deputy Commissioner Godda had written to the Home Department seeking further guidance in the matter. The Learned Counsel has relied upon a judgment passed by this court in WPC number 3894 of 2021 and other analogous cases. ये पार्ट है, ये खुल नहीं रहा पूरा, समीर जी खुल नहीं रहा. Decided on 7/9/2020, decided on 16/12/2022, and has submitted that the requirement to obtain Class 10 certificate from an institution in the state of Jharkhand has been held to be unreasonable and violative of Article 15. The Learned Counsel submits that under such circumstances, the communication of the respondents, the impugned action of the respondents calls for interference, and there is no illegality in the matter of compassionate appointment of the petitioner. The Learned Counsel, appearing on behalf of the respondents, has also gone through the aforesaid judgment cited by the petitioner and submits that the petitioner may bring the same to the notice of the respondent number 2, who shall take it into consideration and pass appropriate order if there is no other legal impediment. Okay? After hearing the Learned Counsel for the parties and considering the aforesaid facts and circumstances of this case and the judgment passed by this court in WPC number 3894 of 2021, this court is of the considered view that there is no requirement of producing a matriculation certificate from an institution placed within the state of Jharkhand. Which appears to be the reason for the impugned action of the respondents. No counter affidavit as such has been filed in the present case, and under such circumstances, this court finds proper to direct the petitioner to approach the respondent number 2 along with the said judgment, a copy of this order and a copy of the records. The needful be done by the petitioner within a period of 2 weeks from today.
3 weeks.
3 weeks from today. Upon filing a representation, the respondent number 2 is directed to pass appropriate order. Committee में जाएगा.
Committee.
By placing the respondent number 2 is directed to do the needful and place the matter before the compassionate appointment committee, who shall take appropriate decision in accordance with law within a period of 4 weeks from the date of communication of this order, from the date of filing of representation. the reasoned order be communicated to the petitioner through speed post. And needful be done accordingly.
And if the
An appropriate orders be passed in terms of the reasoned order.
decision, and if the it is found to be correct, then the
वो appropriate orders.
उसको reinstate करने का
Appropriate orders are
oblige.
the state petition is accordingly disposed of.
Also, case item 5, WPS 375 of 2023.
Yes, petitioner.
The officer is
Yes.
we are filing supplementary counter affidavit.
Great.
If permitted.
You have issued the appointment letter to me. Is that correct? What's your name? आपका नाम क्या है?
विनोद कुमार
अपना appearance दीजिए इनका designation के साथ. What is your designation? What is your designation? Respondent number?
Respondent number 6.
इन्हीं को बुलाया गया था ना? कोई subordinate तो नहीं आ गया?
नहीं. Respondent number 6.
WPS number 375 of 2023. Pursuant to the order dated 2/4/2024, the respondent number 6 has appeared in person and filed a supplementary affidavit, a supplementary counter affidavit. The learned counsel for the respondents has submitted that the appointment letter has been issued to the petitioner. Appointment letter है?
Letter has been issued with regard to giving him joining after election.
Okay. A letter has been issued dated 22/4/2024 so as to give joining to the petitioner, but the effect of the said letter will be given only after Lok Sabha election as the model code of conduct is in force. Counsel for the petitioner submits that the petitioner is satisfied with the letter number 787 dated 22/4/2024 as annexed with the supplementary counter affidavit filed today, and therefore he does not want to pursue the present writ petition. He simply submits that appropriate order be passed so that the letter dated 22/4/2024 is complied immediately after within a period of 1 week from the date the period of model code of conduct ends, right? After hearing the counsel for the parties, it appears that the grievance of the petitioner has been substantially redressed by virtue of issuance of letter number 787 dated 22/4/2024 annexed with the supplementary counter affidavit. The respondent number 6 is directed to do the needful in terms of the said letter within a period of 1 week from the date of the model code of conduct on account of Lok Sabha election comes to an end. This writ petition is accordingly disposed of. The personal appearance is dispensed with. ये दूसरे ही वेबसाइट में सारा पब्लिश हो गया है क्या रिजल्ट? There are number of such orders being passed. देवघर में देवघर से आए ना आप? तो ये जो पब्लिकेशन हुआ रिजल्ट का, ये कौन से वेबसाइट में आपने पब्लिश किया? JSSC के वेबसाइट में नहीं पब्लिश किया, देवघर वाले वेबसाइट में. You have been issuing letters to number of them, I suppose. औरों को भी इशू किया है. ठीक है जी.
Also, case item 8, WPS 2083 of 2023.
Seen the judgment?
I would like to draw your lordship's attention to only one line of para 4 in that judgment, your lordship.
हाँ जजमेंट हमको, मेरा जजमेंट आपके पास चला गया, मेरे पास
I give it to them immediately.
दीजिए.
We appreciate the argument of the petitioners that they have given best part of their life for the said college, but so far as law is concerned, we do not find their continuous working has created any legal right in their favor to be observed. In the event there was any scheme for such regularization, they could have availed of such scheme, but in this case, there seems to be none.
Para number 4.
4 year. Yes. Reading from SCC.
This Ganesh Digambar.
Jhamdunkar and others. The second last one below it, the biggest one. It starts from we appreciate the argument.
Yes, we appreciate. Yes,
We
please.
appreciate the argument of the petitioners that they have given their best part of their life for the said college, but so far as law is concerned, we do not find their continuous working has created any legal right in their favor to be observed. In the event there was any scheme for such regularization, they could have availed of such scheme, but in this case there seems to be none. We are also apprised that some of the petitioners have applied for appointment through the current recruitment process and so on and so forth. But Your Lordship, in my case, there is a scheme that allows and permits for regularization of service, and also I fulfill the conditions as
For
per.
contractual employees,
Yes, Your Lordship.
there is a scheme
The scheme itself, Your Lordship, the rules that are framed, 2019, it was amended.
that has been considered. Is there any order passed?
Yes, Your Lordship, the minutes of the meetings that I have annexed, by virtue of which the others were regularized, they have referred to the 26/2019 amendment that was made in the rules. If I may draw
You
your
just argue your case. You just give the details and argue your case.
Yes, Your Lordship. Your Lordship, I was.
Give the facts, please.
Yes, Your Lordship, I was appointed on 25th January 2008 from the list of dates.
Yeah.
25th January 2008 by the competent authority, which is Deputy Commissioner Giridi. This was on the basis of daily wages I was appointed, and I was being paid 183 rupees per month.
This
And-
is daily wage.
Yes, I was being on daily wages. Thereafter, in 2013, they came up with an advertisement for computer operator cum clerk appointment. 19th January
You have said
2013.
2013, right?
Yes, Your Lordship.
Okay.
2013, they came up with this particular advertisement. I applied, I got selected, and thereafter I was working continuously, which
Just
has
a moment. This advertisement was for what purpose?
This advertisement was for appointment of computer operator cum clerk on contractual basis under Jharkhand Building and Other Construction Work Welfare Board under the chairmanship of Deputy Commissioner Giridi. And I was duly selected, and I have been working thereafter.
What
And
is the advertisement?
annexation to Your Lordship, page 29.
Please kindly place this advertisement.
झारखंड भवन एवं सनिर्माण कर्माकर कल्याण बोर्ड के अंतर्गत जिला स्तर पर कंप्यूटर ऑपरेटर कम क्लर्क के पद संविदा पर नियुक्ति हेतु सादे कागज पर अपना पूरा नाम, पिता का नाम, स्थायी आवास, दूरभाष संख्या, जन्म तिथि, पत्र व्यवहार का पता, शैक्षणिक तकनीकी योग्यता, कार्य अनुभव दर्शाते हुए योग्यता एवं अनुभव संबंधी प्रमाण पत्रों की शैक्षणिक योग्यता प्रमाण पत्र एवं आयु प्रमाण पत्र की फोटो प्रतिलिपियां आवेदन पत्र के साथ संलग्न करें एवं 2 पासपोर्ट फोटो के फोटो सहित वांछित योग्यता रखने वाले इच्छुक अभ्यर्थी वॉक इन इंटरव्यू हेतु कॉलम 6 में अंकित तिथि एवं समय पर उपस्थित हों। योग्यता, अनुभव एवं अन्य प्रमाण पत्रों की मूल प्रतियों के साथ लाना अनिवार्य है। यदि आवेदन वर्तमान में कहीं कार्यरत है तो नियोजन का अनापत्ति प्रमाण पत्र भी अवश्य प्रस्तुत करें। अपूर्ण एवं समय सीमा के बाद प्राप्त आवेदनों को स्वीकार नहीं किया
That's
जाएगा।
recorded. Next.
And then the qualification was
That's right. You were qualified. You were appointed
Yes, Your Lordship.
on this is a appointment in the year 2013.
Yes, but I have also been continuing by
That continuity cannot be taken into consideration.
So
Your
I was-
appointment is from 2013.
and I have been continuing and continuously working. Up to 23, I have annexed my renewal letters as well, Your Lordship, which is by
What is the
Annexure 7,
last renewal?
Annexure 10, Your Lordship, which is at page number 45. उपायुक्त गिरिडीह के आदेश दिनांक 5/7/2022 के आलोक में जिला सामाजिक सुरक्षा कोषांग गिरिडीह में कार्यरत कंप्यूटर ऑपरेटर श्री राजेश कुमार वर्मा एवं श्री अवधेश कुमार वर्मा को दिनांक 1/4/2022 से 31/3/2023 तक अवधि विस्तार की स्वीकृति प्रदान की जाती है. And as on date also he is working on it. So I was continuously working on that post, and thereafter, Your Lordship, in 2015 there was a letter that was issued by to the deputy commissioners to appoint people against vacant sanctioned posts of accounts clerk as per the rules, and accordingly the deputy commissioner then in 2016 an order was passed by the principal directorate whereby I was now put from 183 rupees, now I was shifted to 16,490 rupees per month salary. That's what I was being paid from November 2016 onwards. Then to the 26/2019, this is very important, Your Lordship. This is the date by which, after the Narendra Kumar Tiwari judgment, there was an amendment made to the rules, and the cut-off date was increased from 10/4/2006 to 26/2019, and accordingly it was directed that please make appointments and regularization of employees who have not been regularized.
Where is the scheme?
This is Annexure 5, page 34, Your Lordship. Page 34.
This is not the main scheme. This is just the amendment.
Yes.
Where is the main scheme?
Amendment. The relevant part is here, Your Lordship, where they talk about the 10-year rule.
Rest is irrelevant. No part of a statute becomes irrelevant.
नरेंद्र कुमार संख्या माननीय सर्वोच्च न्यायालय में दायर सिविल अपील 7423 7429 7429 2018 arising out of SLP civil number so and so नरेंद्र कुमार तिवारी एवं अन्य बनाम झारखंड राज्य एवं अन्य में दिनांक 1/8/2018 को पारित न्याय निर्णय के अनुपालन में कार्मिक प्रसूत तथा राजभाषा विभाग झारखंड रांची को अधिसूचना संख्या 1348 दिनांक 13/2/2015 द्वारा अधिसूचित झारखंड सरकार के अधीनस्थ अनियमित रूप से नियुक्त एवं कार्यरत कर्मियों की सेवा नियमितीकरण नियमावली 2015 के नियम 3 के परंतुक में प्रदत्त शक्तियों के अधीन उक्त नियमावली में
That's right. 10 years they have set for irregular appointees.
Yes.
सेवा नियमितीकरण करने वाले अनियमित रूप से नियुक्त कर्मियों, right?
को सेवा
This is for irregular appointees.
Yes.
Alright. So,
Yes. Your Lordship, also I would like to draw your attention to Annexure 11, page 46.
yes.
This is minutes of the meeting, and if I may be permitted to read, वित्त विभाग एवं विभाग अंतर्गत विभिन्न निदेशालयों एवं कार्यालयों में कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग की अधिसूचना संख्या 1348 दिनांक 13/2/2015 तथा अधिसूचना संख्या 4871 दिनांक 26/2019 के आलोक में अनियमित रूप से नियुक्त कर्मियों की सेवा नियमितीकरण पर विचार करने हेतु प्रधान सचिव वित्त विभाग की अध्यक्षता में गठित समिति की बैठक दिनांक 27/6/2022 को 11:30 बजे में प्रधान कक्ष में आहूति की गई.
That's right. What do you want to say?
Your Lordship, thereafter they have laid down who needs to, if you fulfill, then we will consider it. In my case, Your Lordship, I fulfill all of these criteria. I am duly competent. I've been working continuously on the same post since 2008. There have been similar persons who though were working under the post of computer operator, have thereafter been appointed as clerks. In page 62, they have made a statement to that effect as well, Your Lordship, of this, the second and third para of
They have
page
been
62.
regularized by virtue of this scheme.
Under this particular scheme, by giving reference to this scheme, Your Lordship,
Where is that?
26 2019.
Where is that? That they have been regularized by virtue of this scheme.
The 26 2019, the one that we just referred the amendment.
So
Your
who
Lordship.
has been regularized?
All these persons, Your Lordship, who were working on the post of computer operator in various districts.
On contractual basis?
Some were on contractual
We
basis.
do not know
They have mentioned it, Your Lordship.
that they were working on contractual basis. Where have they mentioned? Not even one of them. There is a difference between irregular appointment and contractual appointment. Contractual appointment is not irregular appointment.
But Your Lordship,
It is just a contractual appointment.
even from the start, Your Lordship, if we see in 2008 also, it was an irregular
That's it.
appointment.
You listen to the order, please. The learned counsel for the petitioner is present. Nobody appears on behalf of the respondents. This petition has been filed for the following relief. The learned counsel for the petitioner has given the factual background by submitting that that white letter number 33 dated 25/1/2008, the Deputy Commissioner Giridi, who was the competent authority, had appointed the petitioner as computer operator in Social Security Cell Giridi during the period from 1/1/2008 to 31/3/2008 on payment of daily wage of rupees 183, and thereafter the services of the petitioner was extended from time to time. The learned counsel submits that on 19/1/2013, the petitioner participated in selection process pursuant to advertisement on the post of computer operator clerk on contractual basis under Jharkhand Building and Other Construction Workers Welfare Board, functioning under the chairmanship of the Deputy Commissioner Giridi. The petitioner, being duly qualified, was selected pursuant to the advertisement, and thereafter the petitioner has been continuously working. A letter dated 10/6/2015 was issued by the Director Social Security Jharkhand to all Deputy Commissioners to appoint people against vacant sanction post within bracket accounts clerk as per the required rules. The salary of the petitioner was enhanced to rupees 16,490 from November 2016 by virtue of the order passed by the Principal Secretary, Directorate of Social Security, Government of Jharkhand, for the purposes of applicable to all computer operators in the Social Security cell. The learned counsel submits that the petitioner is entitled for regularization in terms of the circular issued by the state government pursuant to order passed by the Honorable Supreme Court in the case of Narendra Kumar Tiwari and others versus State of Jharkhand in civil appeal number 7423-7429/2018. And the cutoff date of the earlier circular of 2015 dated 13/2/2015 has been shifted. She submits that the petitioner has been continuously working since 2008 and having completed 10 years of service is entitled for regularization under the scheme for regularization framed by the state government dated 13/2/2015 read with the circular dated 26/2019. Yes, right. The learned counsel has also submitted that in terms of Annexure 11, a number of computer operators have been regularized. The learned counsel has relied upon a judgment passed by Honorable Supreme Court reported in bracket 2015, that includes 8 SCC 265, Amarkant Rai versus State of Bihar, and has referred to paragraph
10, 11, 12, 13 and 14.
Is there any portion of the judgment you have left out?
No, also because 10, 11, 12 discusses Umar and thereafter 13 and 14 is similar to our facts. The night guard was posted at the post of daily
Paragraph
wages.
13 and 14 of the said judgment to submit that the daily wage employee who was to submit that the appellants before the Honorable Supreme Court had served the university for more than 29 years on the post of night guard and had served the college on daily wage, and therefore in the interest of justice the Honorable Supreme Court directed to regularize the services of the appellant with retrospective effect, that is with effect from 3/1/2002, the date on which he joined the post as per the direction of the registrar of the university. The learned counsel submits that in view of the aforesaid judgment and in terms of the scheme for regularization, the circular of the year 2019 having been placed on record, the petitioner is also entitled for regularization. after hearing the learned counsel for the petitioner and considering the facts and circumstances of this case, this court finds that though the petitioner was employed on daily wage with effect from 25/1/2008, but the employment of the petitioner as daily wage ended in view of the fact that the petitioner had participated in the selection process pursuant to advertisement dated 19/1/2013 and was appointed on purely contractual basis. The advertisement has been placed on record as contained in Annexure 2 series, which clearly provides that the employment was for a period of 1 year contractual basis subject to renewal. It further appears from the records of this case that the services of the petitioner was renewed from time to time. Contractual service of the petitioner was renewed from time to time, and last such renewal which has been placed on record is at Annexure 10, which is for a period from 1/4/2022 to 31/3/2023. This court finds that the petitioner, though initially appointed as daily wager, but subsequently was appointed as on contractual basis pursuant to advertisement, and the contract of employment of the petitioner was renewed from time to time. So far as the scheme for regularization of the state government, which is dated 13/2/2015, and its extension and its modification dated 26/2019 within bracket Annexure 5, it is apparent that the scheme for regularization was for those persons who were irregularly appointed and were continuously working for a minimum of 10 years. This court is of the considered view that the said scheme for regularization as placed before this court as contained in Annexure 5 is not applicable for contractual appointments. As the contractual appointments are not irregular appointments. The petitioner was duly appointed on contractual basis pursuant to advertisement. The claim of the petitioner that the petitioner has worked continuously from 25/1/2008 is also not correct in view of the fact that the appointment on daily wage of the petitioner ended once the petitioner was taken into employment on contractual basis pursuant to advertisement. So far as the judgment relied upon by the petitioner reported in bracket 2015 bracket close 8 SCC 265 is concerned, the same does not apply to the facts and circumstances of this case in view of the fact that in the said case one daily wage employee had continued to work for 29 years and appropriate orders were passed by the Honorable Supreme Court in the interest of justice. Here the petitioner was employed on contractual basis and it was within the knowledge of the petitioner that the employment is contractual and was subject to renewal from time to time. In this context, it would be useful to refer to the judgment passed by the Honorable Supreme Court reported in 2023 Live Law SC 801 within bracket Ganesh Digambar Jamburkar and others versus State of Maharashtra, wherein it has been clearly held that working for a long period on contractual basis does not create a vested right of regularization. This court is of the considered view that the claim for regularization of the petitioner is not covered by the scheme for regularization as framed by the state, and accordingly there is no merit in this writ petition, which is hereby dismissed.
Also, case item 9, WPS 2188 of 2023.
Is there anything left?
Yes, no, it's very important. They have filed a counter affidavit, but they have taken the cutoff marks of state merit list. If I would be qualified into the state merit list, I would have taken the garb of 142, the special order passed for me 425 petitions. They have said marks secured by last successful candidate in state merit list. State merit list में आ जाएंगे तो हम खुद ही आ जाएंगे. हम तो 425
You
candidates.
just tell us he is amongst the 425 candidates. You have to take the cutoff marks as mentioned in the judgment of the Honorable Supreme Court.
Yes, ma'am.
What is that cutoff marks? State merit list का cutoff marks दूसरा होगा.
Yes.
And maybe, you see, I think there's, even for the state merit list, the cutoff marks was the same as that of the direction of the
वो
Honorable Supreme
चेंज हो गया, वो काफी
कैसे
इंक्रीज हो गया,
change हो
इसलिए
जाएगा?
सारे लिटिगेशंस फाइल्स हो रहे हैं. पहले सोनी कुमारी के स्टे ऑर्डर के बाद डिस्ट्रिक्ट वाइज एडवर्टीजमेंट थी, उसमें अलग अलग डिस्ट्रिक्ट में अलग अलग कट ऑफ मार्क्स थे. उसके बाद स्टेट मेरिट लिस्ट है, स्टेट मेरिट लिस्ट में कट ऑफ अधिक.
नहीं नहीं. What was the cutoff marks so far as your district is concerned?
योर डिस्ट्रिक्ट मतलब दैट फॉर व्हिच मतलब आई हैव टू टेक इंस्ट्रक्शन इन
Yes, Mr. Piperwal, you have said in your counter affidavit that the cutoff marks of the state merit list.
State merit. But
Will it
because-
be different from the cutoff marks as fixed by the Honorable Supreme Court?
My lord, the Honorable Supreme Court had been pleased to observe that the lowest cutoff marks,
Yes. What was the lowest cutoff
the
marks?
lowest cutoff marks, your lordship,
Where is it mentioned?
206. My lord, kindly come to page number 15 of my supplementary.
Page 15.
यस, इट इज स्टेट वाइज मेरिट.
Just.
हाँ, the state wise में ही आएगा.
स्टेट वाइज में आ जाएंगे तो हम तो खुद क्वालिफाई कर जाएंगे ना.
कैसे कर जाएंगे आप?
यदि
आपका
हमको
204 है.
हाँ 206 आ जाता तो हम मेरिट में आ जाते.
6 आज.
तो 425 का
हाँ
जरूरत ही नहीं
बताइए.
पड़ता.
Page 15.
Page 15.
Yes. Marks secured by last successful selected candidate in state-wise
Wise
merit
merit
list.
list 206.
To this state-wise merit list,
Your lordship.
is this the, you see, his cutoff marks, if it is above the cutoff marks as indicated by the Honorable Supreme Court, then
But
he
the
has to be
Honorable
inducted.
Supreme Court has not indicated any cutoff mark.
The
My lord,
lowest cutoff marks.
lowest cutoff
So
marks.
amongst the districts,
My lord,
whatever
yes,
be the
exactly.
lowest,
My lord,
that
yes,
was the cutoff marks fixed by the Honorable Supreme Court.
हाँ, that-
So amongst the districts, what was the lowest cutoff marks? This is what you have to place on record.
My lord, secondly, your lordship.
This is
Subject
the
to-
only-
Yes, absolutely right.
Subject to your lordship's pleasure. My lord, we, as per the available vacancy, your lordship, we have recommended the names of the candidates, your lordship, in the, for the subject history, civics, your lordship, in EBC1 category, your lordship. And the last candidate, my lord, suppose, your lordship, the cutoff marks is 202. For example, your lordship, the cutoff marks is 202, but the up to that, your lordship, the against the available vacancy, your lordship, in the state-wise merit list, your lordship, the last recommended candidate, marks secured by the last recommended candidate will be considered as a cutoff marks, your lordship. This is the cutoff marks, your
No,
lordship.
no, you see, so far as he is amongst those 425 candidates.
My lord, 425 candidates does not mean, your lordship, that we will go down the below
No,
the
no,
cutoff.
that is not his case. You see, please appreciate, you know it, you don't want to understand. The judgment of the Honorable Supreme Court said that you have to take the cutoff marks, the least cutoff marks, right? So amongst the various districts, there will be different cutoff marks.
Different cutoff marks.
You will take the least of that. Right?
Exactly correct.
Once you take the least of that, where is that marks?
My lord,
If
perhaps-
he has secured any marks above that least cutoff marks, then he is entitled, because he will be entitled amongst 425 candidates.
But my lord, if your lordship, subject to your lordship, pleasure, your lordship.
If the heaven falls, we do not know.
No, my lord, I am not on that, your lordship. I am on the law point, your lordship.
Yes.
What was the content? What is the contents of the Honorable Supreme Court order, and what we did, your lordship? Two aspects has to be taken into consideration, your lordship. The Honorable Supreme Court.
Let us go step by step.
My
Honorable
lord,
Supreme Court has mentioned about a cutoff marks, lowest cutoff marks.
Lowest cutoff.
Which according to you is what?
According to me, is 206.
No, not give. Don't give in the number. How do you calculate
My
the
lord,
lowest cutoff marks?
Subject to availability of the
No.
vacancy, your lordship.
No. it is
Subject
not.
to
What is
availability.
the lowest
My
cutoff
lord,
marks?
my
The
lord,
lowest cutoff marks. Different districts had different cutoff marks.
My lord,
So
but
you have
I
to
had
take
to
the
take
lowest
your-
cutoff marks of amongst all the districts.
all the districts, your
Okay.
lordship.
So this is
My
no
lord,
problem on this.
Two aspects, your lordship. Two aspects, your lordship. My lord, the Honorable Supreme Court has not passed any order to even appoint the original petitioner who has obtained the less mark, your lordship. That is not the order of the Honorable Supreme Court. Rather, the Honorable Supreme Court order is that you have to consider their case on the priority basis, your lordship.
What does that mean?
Means, your lordship, the first of all, your lordship, we will take into
The
consideration.
Honorable Supreme Court has clearly stated that those who were vigilant, those who were parties, those who were filing cases,
My-
their case has to be considered first.
My lord,
And after filling up of that vacancy, if there is remaining, it will go to rest. This is the sequence.
My
So
lord-
if any of these candidates just fall above the cutoff marks amongst all the districts, the lowest cutoff marks, their candidature is to be considered. You can't ignore it. First, you have to fill up that, and if there is any further vacancy, then you will be filling up from the state-wise merit list.
My lord, it is observed, my lords, on already published cutoff obtained by last selected candidate. This was observed in the judgment of Satyajit Kumar, the original
Yes.
judgment.
just a minute. My lord, we are concerned for so far the petitioner number 1 is concerned, your lordship. He is history civics. का दो है एक तो आप अप टू डेट आप रिजवी के लिए ये क्वेश्चन रेज किया
वो हम अलग बोलते हैं.
he is comparing his case with a
No,
candidate.
not comparing.
Just
I'm giving
You just disclose the last cutoff marks, the lowest cutoff marks amongst all the districts who were initially selected. Kindly file an affidavit to that effect.
Lord,
Then we will
I-
decide
Yes.
whether he will get it or he will not get
Yes,
it.
sir.
But you file that affidavit.
My lord, I will have to again file, your lordship.
Yes, you'll have
Although
to
your
file.
lordship, I have taken the chart, your
No,
lordship.
we will not
No
see your
post
chart.
is available under history and civics, your lordship. We have made recommendation. That is, my lord, as per their record, your lordship.
No,
I
you
have,
just.
and the marks that his
No
case-
post was available under history and civics. It was initially filled only.
No, my lord, 25% post was to be filled up, your lordship. The promotional post was to be filled up. We filled up that. Previously, your lordship.
You are from the
honourable-
promotional post.
No. That vacancy, your lordship. Suppose, your lordship, there is 10 vacancy for the promotional quota. Your
No,
lordship
you
has
file
the-
that affidavit.
Yes.
This affidavit is absolutely not
Huge
satisfactory.
number of seats are vacant, filed in the Supreme Court.
The learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner is amongst 425 candidates who were party in the writ petition,
Writ petition
which
as well as
travelled
Supreme
up to the
Supreme
Honourable Supreme Court. He submits that he was also a party before the Honourable Supreme Court. The learned counsel submits that as per
He
the
was
directions
not-
of the Honourable
Party
Supreme
is
Court,
report.
the
Affidavit.
But that is I am not disputing.
Aap
His name is in the list furnished by us that he was the original petitioner before the.
that's right.
As well as Supreme Court have annexed
That's
the
right.
status report of Supreme
No
Court is
problem.
denying.
the learned counsel has submitted that
Answer affidavit.
the case of the petitioner has been considered by against the state-wise merit list, and the cutoff marks has been mentioned in the affidavit from the state-wise merit list. He submits that the candidature of the petitioner was required to be considered on the basis of the lowest cutoff marks amongst the various districts,
Yes.
and the petitioner was to be given priority in the matter of appointment.
Okay.
Counsel for the respondent, JSSC,
What?
is directed to seek instruction and file an affidavit indicating the lowest cutoff marks amongst all the districts in the subject history and civics.
EBC category.
For EBC.
In the subject history and civics
EBC category. EBC 1 category.
under different categories,
Yes.
सभी का डाल दीजिए,
सभी
तीनों चारों जितना भी कैटेगरी है सबका डाल दीजिए। बताइए कितना टाइम लगाएंगे आप? डेटा क्या निकालना है तो बहुत सिंपल सा बात
नहीं
है।
नहीं पूरा निकालना होगा हिस्ट्री एंड सिविक्स मोर देन 1500 पोस्ट
आपको क्या पूरा रजिस्टर खोल के बैठना है?
नहीं नहीं पूरा डेटा लेकर निकालने में
एक्सेल
समय
शीट में
लगता है।
कोई
जब
भी
आप
आधे
बोलते
घंटे
हैं कि
operate
डेटा
करेगा
निकालना
तो-
पड़ेगा तो लगता है कि कुछ गड़बड़ है।
नहीं नहीं ऐसा नहीं हम तो अभी बनवा कर लाए
हम लोग का पूरा डेटा हाईकोर्ट का हमारे फोन पर है, आपका डेटा क्यों नहीं आपके फोन पर?
हम नहीं रखते वो सब कॉन्फिडेंशियल है वो सब हम नहीं रखते
Control
वो
plus
सब हम
नहीं
नहीं
लाइएगा,
रिक्वायर्ड योर लॉर्डशिप आई
नहीं लाइएगा तो पूरा रूम भर के रिकॉर्ड मंगा लेंगे
हाँ
और हम खुद बैठ के देखेंगे।
हाँ हम दे देंगे आप बोलिए तो हम दे भी देंगे
Excel sheet दे
हम दे देंगे
Notes
हम दे
control
देंगे
plus
वो
F
मेरे
अब
लिए
नहीं
ज्यादा
कराइए,
easy
कब तक
रहेगा।
फाइल करिएगा ये बताइए?
3 सप्ताह का दीजिए
3 हफ्ता।
3 हफ्ता काहे कि समय लगेगा आई नो इसको हमको बनवाने में फॉर योर लॉर्डशिप काइंड कंसीडरेशन आई
अच्छे कंप्यूटर ऑपरेटर्स रहेंगे तो
इसमें हम
5
कम
मिनट
से
का काम
कम
है।
लग गया 20 दिन 25 दिन टोटल
देखिए
ये वाला क्यों लगने
जब ट्रांसपेरेंसी और क्लैरिटी रहेगा तो 1 घंटा का काम है,
ट्रांसपेरेंसी
और ट्रांसपेरेंसी और क्लैरिटी नहीं रहेगा
है
तो
इसमें
2
है-
साल में भी नहीं होगा।
इसमें है इनका क्या है इनका कहना है इफ योर लॉर्डशिप विल गो थ्रू द प्लीडिंग्स ऑफ द रीट
नहीं,
एप्लीकेशन
please.
ही इज सेइंग दैट आई वाज I
अच्छा,
I
you
could
just
have
file
been
your
awarded
application.
208 marks on the basis of his carbon copy OMR sheet. That is his contention.
The affidavit be filed by 16th of May. Post on the rejoinder, if any, by 28th June. Post on 1st July.
Obliged. ऐसे ये भी हम लोग फाइल किए थे ना आई हैव गॉन टू द रिकॉर्ड एंड देयर आफ्टर एक्सपेक्टेड 203 बट आई
हो सकता है लिखने में गलती हो गया हो। आप स्टेट वाइज डिस्ट्रिक्ट वाइज देखिए।
एक बार हम देख लें एग्जाम में आई भी लिखा
Also, case item 12, the rupees 4892 of 2023.
The petitioners are working as more superintending engineer in the water resources department. Thus, the plain and simple case of the petitioners are that though their juniors have been posted as in charge chief engineer in the department, thus the case of the petitioners also need to be considered. Even for in charge posting, no seniority has to be maintained. Additionally, my submission is that I am not saying that he should be removed and I should be posted, but there are at least 8 posts still vacant, and on record I have said 6 posts, no, 2 posts became vacant after filing of the writ petition. But I have said in paragraph number 17 of my writ petition that there are 6 posts of chief engineers in this state still vacant in my department, and therefore the case of these petitioners are also required to be considered in view of the fact that the juniors are holding such post. And
How
for
many petitioners are there?
4 years.
Okay, 4 petitioners, right?
petitioner
Who are the juniors?
My lords, the junior Milords.
Give me the name.
My lords, the name is Milords Ashok Kumar.
Where is it?
My
Writ
lords,
petition member.
my lords will find it at page 73. Milords.
73.
70.
No, choice. You see, whenever you make out a case of discrimination, दिखाइए आपको writ petition से दिखाइए. आपका annexure से हम नहीं देखते.
Ashok Kumar Milords is his
Where
name.
is it in the writ petition? Respondents are supposed to respond to your writ petition, not to your annexures. Show us where is the name in the writ petition.
In IGL, this is there. The interlocutory application is filed, and in that notes annexure.
What prayer have you made in interlocutory application?
In the writ petition.
Interlocutory application.
In the interlocutory application, notes the prayer was at that point of time that notes during the pendency of this writ petition, notes for staying the.
They do not file response to the interlocutory application. You see, I am telling time and again to the councils over here that respondents are supposed to respond to the pleadings.
Yes.
And not to the annexures.
Yes, it should be
If
there
it is
in the,
not supported by pleadings, I cannot pass an order like that.
it should be clear cut notes a statement in the writ.
Statement करिए
Now,
आप फिर क्या
notes,
करेंगे?
just for a minute, notes, the
आप करिए
shortest possible.
statement.
It's the shortest possible case, notes.
I
Kindly
know
see
shortest
for a minute, page 73. For a minute. My name is notes at serial number 2, 3, 5. Anil Kumar Singh है रक्षी जनरल के ऊपर 2, 3, 4 minutes 5 and not 6 and his name minutes Ashok
You are
Kumar.
only 4 petitioners. You
Ma'am?
have given me 5 numbers. 2, 3, 4, 5 and 6.
पहला है 2 minutes, दूसरा है 3 minutes, तीसरा है जमील अख्तर minutes 5 और चौथा है minutes अमरेश कुमार 6.
4 number is not.
हाँ 4 petitioners है और जिनका हम रेफरेंस दे रहे हैं who is junior to me, he is Ashok Kumar, his name is at serial number 8 and right hand side, extreme right hand side, minus will find at page 73 that he has been posted as chief engineer. It is called Chalu Prabhat, that is in charge post.
No, in absence of specific governments, we can't give you anything else.
And this is the only case, you know, that since my junior has been posted as in charge chief engineer, my case also requires to be considered, you know, for that.
You have produced a gradation list.
Yes, that is 73 I was referring to.
Gradation
I
list.
preferred a representation. Along with that, you know, this seniority list was also enclosed. My representation is minutes annexure 10, annexure 8 minutes page 71. And with this minutes, this seniority list is enclosed minutes, the relevant extract thereof at page 73, from where I made this reference.
Yes, can you pick and choose for for this officiating post, or you have to give preference to the senior person?
My lords, the petitioners were promoted from executive engineer to superintendent engineer in the year 2023, my lords. And the petitioner, by whom the red petitioner is referring to Ashok Kumar, he was granted promotion from executive engineer to superintendent engineer in the year 22 itself, my lords.
So he is
By
senior
virtue
to
of
the
the promotion,
petitioner.
he is senior, not by virtue of the seniority. He may be lower down because he belongs to scheduled reserved category. He was given promotion 15/7/2022. That is why he was
This
given
Ashok Kumar was given promotion on
15/7/2022.
15/7/22 from
Executive
superintending
engineer to superintending engineer. my lords.
executive to superintendent.
My lords.
And when were the petitioners promoted?
The petitioners were promoted from executive to superintendent on 23/6/2023, my lords. That is annexure 6, my lords. Here the Ashok Kumar was not granted the promotion. He is for interim arrangement. He was made as an ad hoc in charge for the chief engineer post.
But otherwise also he is senior.
He is senior. As per the promotion, he entered into that particular post senior to these petitioners.
Prior to this.
Prior to, and the petitioner number 1 was already retired.
Petition number 1 has retired.
Already retired.
During the pendency of
So what relief can be granted?
no others 3.
What about others?
They are going to retire.
No, no.
They will
What,
delay.
you are comparing only with Ashok Kumar.
Yes, ma'am.
He says that he was already in the cadre prior to you on 15/7/2022.
Yes, ma'am.
And you entered the cadre only on 23/6/2023.
Cadre, my cadre
By
is not,
promotion.
my lord, this is the
That's
seniority
super
list which I am referring to. And of course, he belongs to scheduled caste category.
Yes.
Of course, he belongs to scheduled caste category. And therefore, lords, I am making a submission before my lords that once, as per the seniority list, he is junior. It is not a regular promotion. And 6 posts are still vacant. Para 7 I have said, 17. The specific terms in the petition itself. And by think you see. Para 17 is the statement clear cut made, my lords, that there are 6 posts of chief engineers vacant. And lords, of course, this is in charge posting.
How do we issue a mandamus for in charge posting?
For the reason that even in the in charge posting, my lord, seniority has to be maintained.
No, they
Otherwise,
say that
there will be
Ashok
hard-
Kumar is senior to you.
No, he only because he belongs to scheduled caste category. No, he is not the senior to me. He was granted this benefit of promotion at earlier point of time. It is not that he is senior. He is much junior to me. Seniority list itself reflects so.
What is the mean? What is the
And seniority is always dependent on the basic grade. There is an authority of this court. That basic grade में जो seniority रहेगा, that will be maintained for all the time to come. This is well settled. My friend will also not dispute. Recently, judgment delivered by the Supreme Court. So in the superintendent post, all these petitioners are senior to this Ashok Kumar. And I am not saying that remove him. I am saying that since my junior has been considered, you have posted him on higher post. Consider our case also because of the vacancy of 6 posts. They are only simple case before my lords, subject to what your ladyship is.
what is the vacancy which they are saying? Whatever vacancy they are saying, what is the present status of those postings? Or no posting has been done? Some officiating arrangement has been made?
That I have to seek instructions.
You have no idea about that.
Officiating है, in charge है,
No.
it's not regular promotion.
At paragraph 17, he has said the 6 posts are vacant members. Against those posts, few posts have been filled by in charge arrangement members. In charge means they have given for the chief engineer only additional charge was been given members. As per the
So a
initial-
person who is already but they have not yet been promoted as chief engineer. They are only holding the in charge position.
Only one person. ma'am.
This is not a regular promotion.
That is
Ashok Kumar.
and not anyone else.
To others they have given, they are already chief engineers, they have given additional charge.
Okay, they are already chief engineers
engineer
and
and
given
additional
additional charge.
And their serial number 6 is Adhikshat.
But it is only the superintending engineer Ashok Kumar who has been given the officiating charge.
Earlier he was in charge members, in charge chief engineer. By virtue of the court stay order, he was continued members. Thereafter, stay was vacated, and thereafter again, he was no more a chief engineer in charge.
According to you, Ashok Kumar would be junior or senior to the petitioner?
Because he got the promotion, if, as on date, if we are ready to give promotion to chief engineer members, he is having the qualification of Kala. He completed Kalavadi of 1 year, and he is entitled.
He is
Because
entitled for consideration.
For
also.
consideration, he comes under the zone of consideration for promotion to chief engineer.
That's
And the present
And the
petitioners,
present petitioners
will
are
not come
not.
into the zone for consideration of chief engineer, as they were promoted in the month of June 2023, and the Kalavadi for the next promotion is 5 years. Even
We
if they
can't
complete,
issue any mandamus in this. We'll just keep it open to them. If they want to fill, they will consider. Otherwise, we can't issue any mandamus.
Because of the vacancy, otherwise.
We can't.
6 posts are not still.
Maybe vacant. We don't bother about it.
As always.
Okay. WPS number 4892 of 2023. Heard the Learned Counsel for the parties. District petition has been filed for the following relief. The Learned Counsel for the petitioners has submitted that the petitioners were promoted to the post of superintending engineer, and there at the time of filing of the writ petition, the following posts were lying vacant of that of chief engineer. It is a case of the petitioners that junior to the petitioners, namely Ashok Kumar, has been given the officiating post of chief engineer, but the petitioners have been left out. The learned counsel for the petitioners has submitted that there are still vacant posts of chief engineer, and therefore appropriate mandamus be issued so that the petitioners may also work on the officiating post of chief engineer. The learned counsel, appearing on behalf of the respondents, has opposed the prayer and has submitted that Ashok Kumar was promoted to the post of superintending engineer on 15/7/2023. 2022, and the present petitioners were promoted to the post of superintending engineer only on 23/6/2023. He submits that Ashok Kumar is senior to the petitioners and his tenure as superintending engineer is sufficient for consideration of his case for promotion to chief engineer, but the petitioners are still to complete the kalavadi for claiming consideration of the promotion to the post of chief engineer. He has submitted that the vacant post of chief engineer is being taken care of by giving additional charge to the chief engineers in the other departments, and the case of the petitioner cannot be compared with that of Ashok. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it is not in dispute that Ashok Kumar was promoted to the post of from executive engineer to superintending engineer on 15/7/2023, and the petitioners were promoted on 23/6/2023. It is also not in dispute that Ashok Kumar has completed the kalavadi for the purposes of consideration of his promotion as chief engineer, but so far as petitioners are concerned, they have not completed the required period. A copy of the promotion of Ashok Kumar has been placed before this court by the learned counsel for the respondents, which is taken on record. In view of the aforesaid facts and circumstances, this court is of the considered view that the case of the petitioners cannot be compared with that of Ashok Kumar, nor it can be said that juniors to the petitioners have been granted officiating charge and the petitioners have been left out. So far as the petitioners are concerned, they have not yet been promoted to the post of chief engineers, and accordingly accordingly the relief as prayed for, and accordingly this court is not inclined to grant the relief as prayed for by the petitioner under Article 226 of the Constitution of India. However, if the respondents find one or the other person suitable to work as chief engineer on officiating post, it is certainly open to them to do the needful in accordance with law, and if the one or the other petitioners are found suitable, appropriate orders can be passed by the respondents to that effect.
Within a period of
Listed petition is accordingly disposed of.
My lord, the order at what my lords have dictated 15/7/23 because it should be 15/7/22.
Oh, 15/7/22 Ashok Ram ka.
For finance for item 1, the PS 6205 of 2023 from supplementary list.
Well, this case is for payment of the CMPF and family pension, my lord. Husband of the petitioner was employed as peace sector worker in Burkunda Colliery, paid in harness on 23/2/2015. The gratuity has paid to the petitioner, but when the petitioner filed for payment of the CMPF,
You see, in CMPF, they are governed by the nomination.
my
If there is any error in the nomination, as per the applicable rules, you have to go and get a succession certificate.
my lord, CCL has
CCL has done whatever they wanted to. They say it's a clerical mistake.
my lord,
So we do
तो
not.
क्लर्कियल मिस्टेक का तो कोई तो जो सीसीएल ही ना उसको करेक्शन करेगा माय लॉर्ड।
CCL को पेमेंट नहीं
हाँ,
करना है ना.
मतलब
CCL
पेमेंट नहीं करना है माय लॉर्ड, लेकिन करेक्शन तो ही करेगा।
नॉमिनेशन फॉर्म किसने भरा था?
और जो इलिटरेट पर्सन माय लॉर्ड,
Illiterate.
क्लर्क भरा तो उसमें क्लर्क का दोष, इसमें petitioner का कहाँ दोष है माय लॉर्ड? क्लर्क भरा तो क्लर्कियल मिस्टेक ही ना हो माय लॉर्ड। petitioner is a illiterate category
We can't do anything about it. We'll go by the letters of law. If there is any error in nomination, the rule says that succession certificate has to be obtained. That is the rule.
64. Third
माय
point.
लॉर्ड, दिस
On the top.
रोड का एक ऑर्डर है माय लॉर्ड।
64 Roman 3.
Yeah, 64.
In any case, no, provided for the. Which one? 65B.
64 3.
64?
64 start from just page behind. One is for nomination.
Achha, Roman 2.
Roman 2 is for
If no nomination
if no nomination is there. But in this case, there is a nomination. And 3 is for if anyone other than 1 and 2 has to be put in succession certificate. Note has been given in below. Just before 65. If payment has to be made over 25,000, then succession certificate is mandatory.
The learned counsel for the parties are present. This petition has been filed for the following relief. The counsel for the petitioner submits that all the post-retirement benefits has been paid to the petitioner, but the respondent Coal Mines Provident Fund has not released the payment, and therefore the present writ petition has been filed. A counter affidavit has been filed in the present case, bringing on record the nomination with respect to the deceased employee, and as per the nomination, the name of Urmila Kumari has been stated to be the wife of the deceased employee. The petitioner is Shushila Devi, who claims to be the wife. A counter affidavit has been filed by the BCCL, by the CCL, mentioning that there was an error in submitting the nomination form. Yeah. Clerical mistake in submitting the nomination form. To this, the counsel for the respondent CMPF has submitted that the CMPF authorities are bound by the nomination submitted, and in case of any discrepancy or any other claim, a succession certificate is required to be provided. They are not concerned with whatever post-retirement benefits has been paid by CCL to the petitioner. After hearing the learned counsel, the learned counsel has relied upon Rule 64.
Yeah, rules. Para 64.
Para 64 of Coal Mines Provident Fund Scheme.
1948.
After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that the name of the petitioner does not appear in the nomination form which has been forwarded to CMPF. In such circumstances, this court is not inclined to issue any mandamus upon CMPF to release the amount in favor of the petitioner.
My lords,
However, the
Annexure C
petitioner
of the
may
page 12
act in terms
of
of
the-
the provisions of rule of paragraph 64 of Coal Mines Provident Fund Scheme, which clearly provides that in such circumstances,
Roman 3.
64 Roman 3, which clearly provides that in such circumstances, succession certificate is to be obtained from a competent court.
My lord,
Accordingly, the petitioner may
May-
obtain succession certificate from a competent court and raise her claim before the authority of CMPF.
one thing mentioned, my lord. Page 12 of the counter record of the seizure, my lord. Page 12, in the last the point 10, written as a nominee व्यक्ति जो कि नाम है CMPF में अधिकृत है संबंध श्रीमती सुशीला देवी वाइफ लिखा हुआ दैट इज
नॉमिनेशन फॉर्म लिखा हुआ है ना इनका, किसका नाम है? उर्मिला देवी.
मतलब नॉमिनेशन फॉर्म मतलब सर्विस शीट में तो
सर्विस शीट से उनको कोई लेना देना नहीं है, इनको नॉमिनेशन फॉर्म से मतलब. नॉमिनेशन में आपका नाम नहीं है, आप सक्सेशन लीजिए चले जाइए. इतना सिंपल सा बात, कुछ नहीं कर सकते हम. स्कीम में एक तो हर चीज का प्रोविजन दिया हुआ है, उसको इग्नोर करके हम कैसे कोई ऑर्डर कर देंगे?
आई एम नॉट टेलिंग स्कीम यहाँ पर नॉमिनेशन है तो नॉमिनेशन है मतलब ठीक है.
ये वाला जो पैराग्राफ है ना 64 और ये 65 का, ये फोटोकॉपी करके रख लीजिए. वी विल नीड इट फॉर फाइनलाइजेशन ऑफ. हाँ, district petition is accordingly disposed.
Item tutor case 7114 of 2023.
Yes, petitioner.
As per the direction, supplementary counter is
My lord, in this case petitioner, I come before the court for.
Do you want to respond to the supplementary counter affidavit?
No, my lord. My argument, the case is in my lord, a policy is sponsored by Union, is sponsored by Union of India in the matters of integrated child protection scheme. The principal secretary of the state issued the guidelines for all districts to appoint the certain postman. One of the posting was probation cum legal
What
officer.
is your cause of action? You just tell us.
Cause of action in my
You
lord.
participated in the process?
Participated
Selected?
in the interview, selected, annexure 2, and thereafter, till date, he has not been given order, appointment order. This is the case.
That has been cancelled.
That has been cancelled. They are telling now, 2019, we have cancelled. 2018, in November, from their
From where do you say that they have cancelled in 2019?
they have submitted the paper.
Where is it? That they have cancelled it in 2019?
They have submitted annexure 3.
I don't go by annexure. You just tell us in their petition. Where have they stated that it has been cancelled in 2019?
They have cancelled in 2019, my lord.
Where is the order of cancellation?
This is the annexure. Their annexure, my lord, in counter affidavit, my lord.
Page number?
page number 26.
So, yes.
My lord, what I have to say, they issued the final selection list, which is at page number 19 of their counter affidavit, my lord. Page 19, on 29/11/18.
Yes.
And in their counter affidavit at 26, my lord, now they are telling, जिला paragraph 2, जिला समाज कल्याण पदाधिकारी द्वारा समिति के समक्ष जिला स्तरीय बाल संरक्षण इकाई के कुल 10 पदों में DAJB, PWC, डाटा एंट्री ऑपरेटर व हेतु प्राप्त आवेदन एवं अब तक की गई कार्रवाई के संबंध में बताया गया। समिति में उपस्थित सदस्यों द्वारा बताया गया कि यह मामला बहुत पुराना हो गया है, अतएव नियुक्ति के संबंध में निर्णय लेना संभव प्रतीत नहीं होता है। This is the ground they have taken, my lord, and of late I could collect, my lord, from the state secretariat time and again reminders are being given till 23, my lord, कि जल्द से जल्द कीजिए, ये आवश्यक है, सारे अपॉइंटमेंट जल्दी करने हैं। बट विद द अल्टीरियर मोटिव दे
देखिए इस तरह से हम डॉक्यूमेंट्स नहीं लेते।
My
I don't take documents like this. You keep your documents to yourself.
and I have given the judgment of DB, my lord, that after completion of all formality or completion of all selection process,
Which
it
is
cannot
that
be
DB
considered, my
judgment?
lord.
Order. Yes. Which paragraph are you referring to? Which paragraph?
Paragraph, we start from paragraph 31, my lord. The court is of concern that several criminal cases are pending. No, my lord. The final and 36 paragraph, my lord, is in view of our discussion, reasons and analysis, and considering the process has already been completed and only result is required to be published, and due to COVID-19 delay has occurred, which has also been accepted in the counter affidavit of the JPSC, and particularly considering that dispensation of criminal judicial justice system is one on the verge of collapse in the state of Jharkhand due to non-appointment of assistant public prosecutor The impugned orders cannot be sustained in the eye of law. Accordingly, the letter dated 21/1 and the order dated 21/21 are hereby request the respondent state and respondent JPSC are directed to complete the process of appointment pursuant to the advertisement dated 3.
The letter dated 21/1/2022 and 13/12/2021. What were those letters?
My lord,
What were those letters?
letters, my lord.
What were those letters?
Which one, my lord?
These two letters which have been quashed.
These two letters are, my lord, earlier in 2018, that process was started. But later on, they had stopped the process. And
Where is that letter? What is the tenure of this letter which has been quashed by the High Court, by the division bench? What was the content of that letter? You read it, it must be there in the earlier paragraphs. You come to para number 4, page 4.
Para number 4. In WPS 68, 2022, the prayer has been made for direction upon the respondent to publish and publish the final result interview conducted on 4/10/21 to 4/10/21 in advertisement number 3 of 2003 for appointment of the post of assistant public prosecutor. The further prayer is made for direction to finalize the selection process by publication of result pending.
So the decision of the respondents
My lord.
to cancel the examination process was under challenge,
My lord.
right? So here the decision is of 2019.
My lord.
Is it under challenge?
My lord, not under challenge.
Where is it? Show me from the prayer.
My lord, I have not challenged, but I am how I am knowing that 2019 में इन लोगों ने क्या किया है. That is not published. The only in 2023 they again advertised the post, advertisement number 1, which is Annex 4, my lord. Then I came to know and came before the court of law. Between that period, they were assuring time and again कि जल्दी से जल्दी इशू हो जाएगा, मिल जाएगा, आपको अपॉइंटमेंट मिल जाएगा, और लेकिन लास्टली लोगों ने इशू किया. अभी तो ये काउंटर नहीं है, तब नई बात लाए. My lord, and I did that judgment, my lord, and I am submitting one more judgment of the Supreme Court. In which Supreme Court has indicated the cancellation of the recruitment and holding press interview and this. In such circumstances, the cancellation of entire examination held unjustified.
That's it. Which judgment are you like?
In this case, my lord, a written examination was already completed, and thereafter they again advertised. And the Supreme Court told no further written examination. Whatever examination was conducted, that is treated as final. And the last paragraph, Supreme Court rather stated that
Yes, what do you say, respondent?
What's it? Just, as per the two judgments given by the petitioner's counsel also, the post was advertised or not is the same nature as stated in this judgment also, that post was on contractual basis also.
Which one?
Also.
This post?
Yes, sir.
there
Of the
is
petitioners?
on contract basis, my lord.
Yes, sir. These posts are permanent basis, and kindly see the recent.
No, just the selection process of the petitioners in which they had participated.
Yes, sir.
It was on contractual basis.
Yes, ma'am.
Yes, sir.
And the present advertisement is on?
So that is also on contractual basis.
Same Lordship.
On the same qualification, same experience, same all those things, my lord.
Okay,
On
so
which he has already been selected.
आपको रोके थे क्या बहस करने से? आप प्लीज बैठ जाइए, ऐसे डिस्टर्ब मत किया करिए।
Excuse me.
आप बैठ जाइए प्लीज। हर चीज का जवाब आपसे नहीं मांग रहे हैं ना, उनसे पूछ रहे हैं, इसका मतलब कुछ सोच के पूछ रहे हैं। Yes, so it is only on contractual basis.
Lordship.
Okay, so
So thereafter, objection has been invited by the authority Lordship, and that has been cleared. In due process, some delay has been caused. और उसके बाद डिसीजन लिया गया, चूंकि लेट हो गया था, समय पे अवधि फिक्स होती है इसके लिए, तो इसलिए उसको पुराना समय कह के जो लेक्चर अभी SA3 देखा गया था, तो उसके आधार पर that has been cancelled. Meanwhile, Lordship, fresh notification has been come. In view of that notification, the rule has been amended, and 2023 notification has been issued. This is the case.
rule has been amended.
As per the Sthaniya policy has been changed also. That is the
What is your
and so far as knowledge about the development, petitioner said, counsel said he has no knowledge. Lordship. I have stated all
what
that.
is page number 16 of your counter affidavit? Counter affidavit dated 28/2/24.
Yes, Lordship. Page 15 start with that.
Yes, page 15 start. Now that condition has gone.
Yes, Lordship.
So that was the
By this
condition
order-
in the earlier advertisement.
Yes, Lordship. That therefore that has been amended as per the letter issued by the Carving Department. Lordship, that has been mentioned, letter number so and so, Carving Prasasnik Viभाग तथा राजभाषा विभाग Ranchi, and therefore the agreement dated so and so for appointment control basis in different post Jamtara district wide so and so was cancelled. 22 में हुआ था उसको कैंसिल कर दिया गया इसके कारण और फिर फ्रेश नोटिफिकेशन। और जहाँ तक Lordship, so far as about the knowledge what was going in the process, Lordship, kindly see I have stated he was continuously working since 14, Lordship, as a member CWC or member JVG in the same district or Dhanbad or Devghar, Lordship. He is still working today in the Jamtara, Lordship. So
The learned counsel for the parties are present. This writ petition has been filed
My lord,
for the following
if
relief.
permitted 1 minute. My lord, this my case is of 2016. 2018, I have nothing to do, and thereafter. Furthermore, my lord, this petitioner is a resident of Jharkhand, born and brought up in Jharkhand, educated in Jharkhand, serving in Jharkhand as member CWC. That is different thing, and this is being appointed in the society or against the postman, and those judgments are.
This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that pursuant to the advertisement issued as back as in the year 2016 by the Director, Jharkhand State Child Protection Society for different posts, including legal cum probation officer
For all districts of Jharkhand.
for all districts of the state of Jharkhand. The petitioner participated in the selection process of legal cum probation officer
For Jamtara district.
for the district of Jamtara and the name of the petitioner stood stood at serial number 1 in the panel the writ petition further reveals that in connection with some clarification about a complaint, a memo number 969 dated 10/8/2019 was issued from the District Social Welfare Unit, and petitioner was required to be present on 13/8/2019 and clarified his position and was assured that offer of appointment will be issued to the petitioner shortly. When no appointment letter was issued, the petitioner also issued a pleader notice dated 17/1/2020 the Learned Counsel submits that the petitioner has been continuously approaching the respondents for issuance of offer of appointment, but the same was not issued, and the respondent number 225 issued fresh advertisement bearing number 1 of 2023 for the same post in the month of October 2023. Whose last date of submission of form was 6/11/2023. The Learned Counsel submits that once the selection process was over and the petitioner was declared successful, the respondents were not justified in issuing a fresh advertisement. The Learned Counsel has relied upon judgment passed by this court in WPPIL number 3515 of 2021, court on its own motion versus State of Jharkhand and other analogous cases, and has submitted that in the said batch of cases, after the selection process, the government had decided to withdraw the requisition of vacancies and fresh advertisement was issued. They had decided to withdraw the requisition of vacancies and consequently a writ petition was filed to finalize the selection process and for publishing the result. The Learned Counsel has submitted that the court ultimately held that when there was no infirmity with the examination, the impugned decision was nothing but total disregard to relevancies and not allowing to be carried out by irrelevancies, giving a complete go-by to contextual consideration, throwing to the winds the principle of proportionality in going farther than what was strictly and reasonably to meet the situation. The Learned Counsel submits that In such circumstances, the decision of the respondents was quashed. He submits that he has further relied upon judgment passed by Honorable Supreme Court reported in 1990 within brackets supply bracket close Supreme Court cases 692 and has submitted that the decision of the Public Service Commission to cancel the entire recruitment process was held to be bad in law. The Learned Counsel submits that the aforesaid two judgments fully cover the case of the petitioners. The Learned Counsel, appearing on behalf of the respondents, while opposing the prayer of the petitioner, has submitted that a the wide letter dated 14/12/2016, the advertisement was published for contractual appointment of total 13 posts
For 1 year.
for a period of 1 year in which 116 candidates had applied. And thereafter objection was invited. The objection was also filed by the present petitioner on 26/3/2018. And ultimately the final list was prepared on and 7/12/2018 was the date fixed for verification of documents of the selected candidate. However, a decision was taken on 17/10/2019 by all the members of the district level selection committee Jamtara, and a meeting was called for on 21/10/2019 under the chairmanship of the Deputy Commissioner Jamtara, where it was decided that the post of DCPO, CWC and DJP contractual appointment was old, and it was unanimously decided to undertake a new publication for appointment to the post on contractual basis. It has also been submitted that in the meantime, a judgment was passed by this court in WPC number 3894 of 2021, wherein the condition of passing matriculation or 10+2 examination from educational institution within the state of Jharkhand was held to be illegal, and a follow-up letter number 3807 dated 6/7/23 was issued by the respondent, and therefore the advertisement dated 16/9/2022 for contractual appointment in different posts was cancelled and a fresh advertisement was issued. The Learned Counsel submits that altogether 11 posts were advertised, in which 289 applications have been filed, and the process of contractual appointment will be taken and decided after the Lok Sabha election. It has also been mentioned in the counter affidavit that the petitioner was posted and was working as CWC member since 2014 to 2018 in the district of Jamtara. Thereafter, he was in the district of Dhanbad from 2018 to 2021, and further in the district of Devghar from 10/1/2022 to 2/4/2022.
Thereafter,
And then in Jamtara from 5/4/2022 till today. The Learned Council submits that the petitioner was fully aware about the decisions, and still the writ petition has been filed, and the decision to cancel the selection process, which was taken way back in the year 2019, has neither been mentioned in the writ petition nor the same is under challenge in the present proceedings. The Learned Council submits that since there was a decision in connection with the change of policy regarding local resident in the matter of with regard to the class 10th and class 12th qualification, the impugned selection process pursuant to advertisement number 1 of 2023 is in consonance with the state policy, and therefore no interference is followed. He submits that when the advertisement was for a short-term contract period and much time having been elapsed, there was no illegality in cancelling the selection process. He submits that merely because the name of the petitioner appeared in the panel, the same does not crystallize any right in favor of the petitioner. यही आपका total. After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, this court finds that the petitioner had participated in the selection process pursuant to advertisement of 2016 and his name was appearing in the panel. The recruitment process was on contractual basis, and ultimately the recruitment process could not be finalized till 2019, and a decision was taken by the respondents on on 4/10/2019 by stating that the recruitment process had much time had elapsed from the date of advertisement, and a unanimous decision was taken to initiate fresh process by issuing an advertisement. The records further reveal that an advertisement was issued in the year 2022 also, but the said advertisement was also cancelled in view of the judgment passed by this court in WPC number 3894 of 2021, wherein the condition for passing matriculation or 10+2 examination from educational institution in the state of Jharkhand was held to be illegal, and therefore the illegality with regard to such condition was to be removed, and a follow-up letter dated 8/7/23 was also issued, and the advertisement dated 16/9/22 was cancelled, resulting in issuance of fresh advertisement. The counter affidavit reveals that the selection process pursuant to the fresh advertisement is almost over and at the stage of publication of the result, and on account of 2024 election, the result has not been published. This court finds that the selection process was for contractual appointment, which was issued way back in 2016, and the selection could not be made, which became a reason for cancellation of selection process in 2019. The decision to cancel the selection process has been annexed along with the counter affidavit, but the same is not under challenge in the present proceedings. The petitioner has sought a mandamus from this court for publication of, for issuance of offer of appointment to the post of legal cum probation officer, and has sought prayer for quashing the advertisement. This court is of the considered view that the decision which was taken way back in 2019 to cancel the selection process, which is not under challenge in the present proceedings. The said decision was followed by another advertisement for selection dated 16/9/2022, and on account of the policy regarding the aforesaid policy, which was subject matter of consideration in WPC number 3894 of 2021, the advertisement of the year 2022 has been cancelled and fresh selection process has been instituted. This court finds that in view of the aforesaid facts and circumstances, no relief can be granted to the petitioner so far as the judgment passed in WPPIL number 3515 of 2021 is concerned. In the said judgment, the decision to withdraw the requisition, which was relating to advertisement, was under challenge, and this court has also referred to the judgment passed by the Honorable Supreme Court in Mohammed Rashid, Director versus Local Bodies, New Secretariat and others, reported in bracket 2020 bracket close 2 SCC 582 para 14, wherein it has been ये वाला this court held by referring to the aforesaid judgment in paragraph 32 that it is well settled that merely on appearing in examination and even appearing the name in the merit list, a person is not having any right. Such proposition of law was not in dispute. But the but in spite of the said judgment, the this honorable division bench was of the view that the dispensation of the criminal justice system was on the verge of collapse in the state of Jharkhand due to non-appointment of assistant public prosecutor and accordingly the impugned orders of withdrawal of requisition were quashed. This court is of the view that no such circumstances has been placed on record by the petitioner, and the recruitment process of the year 2023 is almost at the stage of finalization. In such circumstances, this court finds that the aforesaid judgment passed in WPPI number 3515 of 2021 does not help the petitioner in any manner. In the judgment passed by the Honorable Supreme Court reported in 1990, bracket close supplementary, bracket close SCC 692, it was found that the selection, that there was no defect in regard to the selection process, and there was no justification for cancelling the written examination. But in the present case, the respondents have cited reasons for cancellation of the selection process way back in the year 2019, which was followed by 2 subsequent advertisements. And as of now, the policy of the state with regard to obtaining the educational qualification from within the state of Jharkhand has now been clarified by issuance of subsequent letters. Therefore, the said judgment, which has been relied upon by the petitioner, also does not apply to the facts of this case. As a cumulative effect of the aforesaid findings, there is no merit in this petition.
दो बातें हमारे इंटर कर दी हैं कि 2019 का जो इनका पोस्टपोनमेंट का ही है वो सर्कुलेट नहीं हुआ है, नो नोटिस वाज इशूड, एंड फर्दर टू दैट the advertisement of earlier advertisement was issued by the director of the department, and this committee has no power to cancel that.